Mike Nitardy from Frost Brown Todd has just dialed in too.
Hi, Pádraig. How are you?
Not too bad. Good to see you, sir.
Good to see you too.
And Kim Walker. Kim's joining us from Shakespeare Martineau. Kim, we're in a waiting room just before we go live online. So
you know, we are on live now, just we can start the conversation. Yes. Everything is already happening.
Yes. Oh, thank heavens I didn't swear in that period. Well, our session today is a session it's actually really a global topic. So I'm just humbled by the fact, firstly, to have the pleasure of being here and being the host and moderator. But also being part of this network called Privacy Rules that gives us access to people from around the world who have real expertise in issues around data, privacy, and some of the ethical issues that arise from that, particularly if you think of what we're facing here and now at this point in the world, a real global issue, but also an issue that is at the heart of public health, ethics, and law. And to that end, I'm delighted and honored to be joined by Agnieszka, Mike, and Kim. So if I could just ask you to briefly introduce yourselves, and then I'll come back to you, Agnieszka, and we'll roll into the panel from there.
Yes,
please introduce yourselves.
Yes, I'll start. Thank you very much. Thank you so much, Pádraig, for inviting us. And I think it's a fascinating topic and a great combination of our global expertise. My name is Agnieszka Wiercińska-Krużewska. I'm an advocate and lawyer in Poland, dealing mainly with data privacy and media law. So I'll be very happy to introduce you to some Polish perspective on some ethical issues of the use of technology in our pandemic world.
And I'm Kim Walker, partner from Shakespeare Martineau in London, specializing in data privacy, among other things, and particularly interested, obviously, in the way the GDPR affects this issue. So great to be here.
Yes, hello, my name is Mike Nitardy, and I'm a member at Frost Brown Todd here in the greater Cincinnati, Ohio area. My work is primarily in commercial litigation and in data privacy and security.
So, and we should be joined by another gentleman, Mohsen, in the fullness of time, but for now, let's move ahead. And what I thought we would do is that we would start by looking at some of the specific pandemic technology solutions that have come forward, just as a teaser to see some of the issues that they throw up, and then move from that to the broader issues, because what we're hoping to address as a theme of this slot is the theme of what we can look forward to in a post-pandemic world in respect of this convergence of law, ethics, and public health. So with that in mind, if I could turn to Agnieszka and ask maybe just to speak a little bit about the home quarantine app in Poland, because at the point of its introduction, it was quite a controversial technology solution. So why was that? Mm-hmm. And what improvements were made from that initial launch?
Yes, the quarantine application, I think it's a very, very interesting topic. I mean, it was introduced quite early as a response on many people's concerns that the physical visits of police at home attracts a lot of attention from neighbors. So people were concerned, actually, that the fact that the police is coming and checking on someone, first of all, attracts attention anyway. And secondly, at the beginning, with a lot of scareness and about the coronavirus, people were scared that if someone is sick around them, they might get contagious as well. So the government came with the idea of introducing the application that would actually help police not to investigate every person being sent to the quarantine. So I think at the beginning, the idea was quite well perceived by the society. But then it started to attract a lot of questions around its legitimacy in terms of, especially in terms of data privacy. So what were the main concerns? The main concerns were that, the scope of data that is being collected by the application. So the information on the application actually indicated that the app collects the surname, the location, the photograph, the photo of a person, the mobile and the phone number, and that's it. But where people started digging into actually what, from technical point of view, the application is able to collect, it's much more. So the application actually has access to all the content of the mobile device of an individual, access to all the photographs, all the content on the applications, the Wi-Fi being used. So basically everything what we saw on the device. So that was the first concern. The second concern was the length of data retention. The bylaws and the terms and conditions of the application, they indicated that all the data is being stored for 6 years, which is quite a long time for bearing in mind a 14 days period of the quarantine. The 6 year period comes from the general civil law rule on the time ban of the claims. So the creators of the application said that if there are any claims, they're time banned after 6 years. That's why all the data has to be stored for 6 years. The third concern was the entities that actually have access to the data. So the general information of the application indicated 5 institutions and companies that would be allowed to have access to the data being collected, and all of them pretty legitimate institutions. But under the Polish law, all the secret service institutions, public institutions, they don't really apply data protection laws. So the third concern was that basically this data is being stored by the ministry, and the ministry has to give access to all the secret service authorities upon their request, without applying any data privacy laws and without really having any consent from the data user. So the main concern was that the app will be used for artificial intelligence learning of the people's profiles, really in the use. So these were the main concerns that were raised by watchdogs in Poland and also some other nonprofit organizations. And I think it started to be discussed, and also a lot of questions were put to the Ministry of Digitalization. So ministry started to answer the questions. So for example, they decided to delete the photograph after the quarantine period and only keep the other data in order to, let's say, reserve the right for the claims. They also informed that all the other access to the mobile device and the content of the mobile device will be upon the separate consent, like a pop-up window that would give you the right to deny access if necessary. So, step by step, I think that certain measures were introduced to limit the concerns that they were raised around the application. And now, from the time is passing, there is less and less people being sent to quarantine. People are treating all the measures with a lot of reluctance, I have to say. So also this application is being, very rarely used right now because of the change of the attitude of people towards the measures that were imposed by the government on the Polish citizens.
My word, I have a degree of sympathy simply because so much needed to be done so quickly in an environment that was so new. But that sounds like almost a train wreck at the start, and that improvements were swiftly made. if I could move to Mike. Oh, sorry, I should interject and just say we have been joined by Mohsen. So Mohsen, would you like to say just a couple of words to introduce yourself before I move on to the next question to Mike? You're on mute, Mohsen.
Oh, sorry about that. Yes, I'm Mohsen Rezayat of Siemens. I lead the Advanced Solutions Group and responsible for research in a division of Siemens.
Thank you very much. So coming back to Mike, so in the US, one of the most interesting projects is the Google Apple project. And that's been met generally with warmth and support. I have two questions for you. One is, how did they sort out the billing? Google Apple or Apple Google? And but more importantly, what were some of the features that made their project more broadly acceptable?
Yeah, the first question, I'm going to let the marketers handle that one, but that's a great question. I'm sure that they've thought about that as well. But the second question is also a very good question. I think it's key to the reason that there's been better acceptance, at least of the idea of this type of notification tracking or exposure notification, if you will. And that's because of the way that Google and Apple have decided to do this is not through any type of location data, but through basically making it so that it's Bluetooth from certain handhelds talking to each other in terms of proximity and closeness of the individuals that are carrying their handhelds. And so what that means is that instead of tracking, developing apps that track geolocation or GPS data so that the people that own the app can track where people have been, the way that the notification would go would be through individuals going about their daily lives and then having their handhelds whenever they get in proximity with another person that has a smartphone or a handheld device, having their devices, so to speak, have a handshake between beacons or anonymous Bluetooth identifiers that would then be stored in each other person's phones. And so the way that would happen is that Google and Apple are giving the technology for the API information to the health organizations to develop their own apps so that the individuals would download these apps. And so when someone, let's say, gets a positive test for COVID-19, they would input that into the app, and then it would download all of the Bluetooth identifiers that that person had been in contact with through a certain amount of time. And then the app in turn would notify those Bluetooth numbers throughout the app. I guess the people that are using the app. And so what that provides is a more anonymous and privacy protecting way of letting people know if they've been exposed to those that have tested positive for COVID. It's completely different than tracking movement. And so that's received a lot more buy-in from the public so far. I know that in the United States, there are 3 states, North Dakota, Alabama, and I believe it's Mississippi is the other one that has already their public health agencies are working with them to develop apps along that line.
Interesting stuff. Now, if you move to the UK, rather controversially, the NHS COVID-19 tracker decided not to go with the decentralized Google Apple project, but instead to go with a centralized version. Could you talk us through the issues relating to that decision, what the controversy was, and what the government or institutional response was to those controversies? Kim?
Yes, certainly. In fact, the government is slightly hedging its bets. The app hasn't been launched, the centralized app hasn't been launched, and the government has asked the technology companies to develop an Apple Google version in parallel, just in case the centralized version is either doesn't get through Parliament or proves to be totally unacceptable in terms of download, the public accepting it. But the thinking of going for the centralized option is that it enables the public health authorities to get a sort of overview of the spread of the virus throughout the UK. I mean, the idea is that the data in it is entirely anonymous, but when you sign up, you have to give the first few letters of your postcode so they know roughly where you're from. And so it enables them to sort of track and look out for hotspots and take any policy actions that might be required as a result of that. They say it also enables them to carry out risk modeling to decide, which contacts are most at risk. So the public health authorities have anonymous data to give them a picture of how the disease is spreading, and anonymous contact group graphs and so on that they can analyze. So if they discover that there's somebody who appears to be spreading the virus particularly well, they can be given a higher risk rating, and the algorithm, I think, can be tweaked to take account of that fact when they're deciding who they need to alert in terms of the contact. The idea also is that it enables the authorities to stop malicious interference with the data and with the app. There's talk that people might want to report themselves as having had COVID-19 so that in due course they'll be given an immunity passport, and they want to be able to try and stop that. So clearly the Apple-Google app is more private, but the view in the UK, or of the UK government at the moment, is that we need the experts to be able to sort of carry out sort of more analysis than the Apple-Google model would allow.
So actually, if you think about it, if you think about the topic, even the title to our talk at the moment, which is balancing privacy, ethics, and public health, it's a classic case of where different governments are falling out on that balance. In the UK, more of a sense that yes, privacy is important and we'll give a certain weight to that, but also we need richer data and more control over that data in order to be able to manage the public health issues. So the notion that there is an absolute right to privacy has to be discarded. It never existed in the first place, because that is a right that is relative. But this notion that you have to have multiple points that you need to balance and weigh against each other. One of the things on that, and this, if I can turn now to Mohsen, who's on mute at the moment, just to, we've spoken quite a bit already about this idea of ethics and ethics being at the core of this particular issue and this topic. Now, as lawyers, we deal in documents for the most part. So we could read a product sheet or a fact sheet about a new technology solution or a white paper on it. And it will say various things like, we have adopted a privacy by design or an ethics by design approach to developing this technology solution. How do you, from the hardcore tech perspective, how do you actually stress test that? What does that mean to a person in your role?
Yeah, I hope you can hear me well. I'm going to probably repeat some of the same points that previous speakers made, but probably in more technical terms. But let me answer your second question first, and we can look at the first one. Ethical by design, to me, is basically ethical risk management. And it includes addressing bias, unintended consequences, misuse of personal data, and lack of explanation for technology-based decisions. I should also probably add corporate value alignment, brand and reputation, legal and financial risks that must also be managed. If we don't consider these issues, whatever we build would be impractical, ineffective, and most likely damaging. For example, any mobile app should have a strong privacy model. Otherwise, we won't receive accurate data because people don't trust it. And it could also bring social harm to individuals. Now, to answer your first question, let's look at the COVID Watch app, which is very similar to what the previous speakers were discussing. This app performs automatic decentralized contact tracing using Bluetooth proximity networks. It's an open source app and it demonstrates how to preserve both human life and human rights. All the data that it collects is voluntary and fully anonymized. And by generating a new random number for each contact event and then storing this number via Bluetooth on any phone that also has this same app in the vicinity for about more than 15 minutes, people can do tracing without storing or transmitting any personal info. Now, compare this approach with far-reaching state surveillance that by the standards of GDPR and most democracies would be considered highly invasive and most likely unlawful. What is being demonstrated by COVID Watch is that when users can alert recent contacts without anyone being able to trace the information back to them, they will be willing to voluntarily share accurate data since they know their data is safe. Now, of course, we still have to wait and see how people adopt apps such as COVID Watch, but the point is that stress testing, in my opinion, must start with a viable design that embeds trust in people that are using that technology.
And I guess if you don't get it right at the outset, you wind up in a scramble trying to, put things right after the horse has already bolted, which is not an ideal way of doing things at all.
Absolutely, yes.
Kim, if I could come back to you with a question which is based around, the fact that if you look at the range of pandemic tech solutions that have come through in a very, very short period of time, there is a risk of just looking at tech as simply being, oh, here's a problem, here's a fix, and that's it, we can sort this out. A tech solutionism that is a danger in itself. I mean, there has to be a broader response to what we're dealing with, in the sense that when you are dealing with the pandemic, you're dealing with something that is truly global, that doesn't know that it's crossing boundaries and going between different jurisdictions. And that requires an institutional response or a form of response maybe within a nation, but also internationally or supranationally. Have you seen any trends in that are taking things out of a purely tech conversation into a broader society conversation in the UK?
Yes, I mean, this follows very much with what Mohsen has just said, that there's the technology aspect and get you so far. There's sort of data protection law, privacy law that can get you so far, but then ethics and data ethics is a layer on top of all of that. And data protection law still can leave the potential for ethical and human rights risks. Even if you follow data protection law to the letter in some senses, because of the vagueness and the openness and the way the GDPR works, it applies principles rather than specific legislation. You need some sort of independent oversight from governments who think that they're complying with the law. They've said, we'll only use the data for relevant research in compliance with the GDPR. What does relevant research mean? So in the UK, we've established a data ethics oversight board. It's meant to be independent. I think it is independent, made up of data scientists, academics, and data ethics professionals, independent of government. Its remit is to promote the ethically appropriate achievement of the app project. And it's meant to ensure it asks all the right questions of government, it gets all the right answers, hopefully, and it holds government's feet to the fire in a data ethics sense. So that's one thing that can happen. The second thing is specific legislation, which I think is something that we're looking for in the UK. We haven't got it yet. We haven't got our app yet. But as I say, the GDPR imposes principles, but as I think has happened in Australia, you need a little bit more certainty as to people's rights to have their data deleted, when and who declares the pandemic over, so that that the data can no longer be used, and all those kinds of things. Forbidding access to anyone other than the health authorities, so it doesn't get access. Access isn't given to the Home Office, or it isn't transferred overseas to the US under the Patriots Act or under anti-terrorism legislation elsewhere. I think certainly in the UK, we're looking for specific legislation that I hope will, deal with some of the issues that Agnieszka talked about right at the beginning.
Can I just butt in, if that's okay? This is Monty Mumford. I'm a bit late. I'm your moderator. I'm sorry. If you just bring me up to speed, the gentleman who's speaking at the moment, and then I'll take over, please.
Sorry, I think you might be in the wrong session. Sergey?
Yes, I'm here. Monty, please, are you from this session or not? Or you're just going to be as attendee being participated in?
Well, they've sent me a. They sent me.
Yeah.
Is that Ivan?
Yes, not Ivan. Yeah, this previous session. Please keep quiet a little bit. Yes, because we have to finish.
So I bombed you.
Okay, Monty.
I'll shut up and I'll wait for you to finish. You're coming to the end, yeah?
For that, yes, go ahead.
You're coming to the end.
Our allotted time is until 1:30. Very good. Agnieszka, I was if I could turn to you and maybe just ask you this, partly building on what Kim was speaking about. It's interesting there that the UK took an approach where legislation was needed. Australia has done likewise. Funnily enough, Singapore, with similar technology to what's used in Australia, didn't use legislation. But you hear all of this about privacy not being an absolute right on the one hand, and you don't want an Orwellian state of mass surveillance of personal information on the other side, and all of how do you achieve that balance in practice? Because it can be quite theoretical. How do you achieve the certainty that Kim was speaking about? If you move it back to the granular thing of looking at a specific tech solution that is being proposed, is there a way that you can make it concrete in terms of assessing whether that does achieve the right balance? What tools are there for that?
Yeah, a couple of years ago, I would think that this is a very theoretical question for me, living in Poland, a democratic state. But looking at the recent events in Poland and Hungary, probably, I have to take this question very seriously, I have to say. So all of a sudden, all these measures in practice are more important than they used to be, because there is, I think there is lack of one of the principles, lack of trust in the state. So something that is, I think, extremely important, and all these tools have to be put into achieving this goal, is to, let's say, regain the trust in the state, so that the state is using the apps, the data, the technology for legitimate reasons. And I think that they are defined in the laws. They're defined even in GDPR, how and why and what you should do to inform people about using their personal data. But if the state is failing, then where are you looking? You're looking at the media, So I think it's really, in practical terms, very important to support free media. And I think that this is what we try to do in Poland right now. The second is to support the court system. So at the end of the day, this is where you can get justice and where you can say that certain public institutions abuse their right to access to your privacy, to access to your data. So I would think that from the practical point of view, and it's really, I'm talking from practice here in Poland, is fighting for freedom of media and fighting for really free judicial system in the country. From a more practical point of view, and I think that Mohsen, that you mentioned, and a very interesting point, if the government, if the state is producing applications or technology that are being used to use our data, then do it on the open source, or do it in a way that it can be verified by the third party. The application that I was mentioning at the very beginning, the quarantine application in Poland, is not done on the open source. It was the technology that was used, it's commercial technology normally being used to verify the correctness of display of the products in the supermarkets by the brand owners. And no one has access to these source codes because it's a commercial software that is normally being sold. So, I think that there are many ways to safeguard our privacy, but I would say that media and free judicial system are the ones that are the most important.
And thinking through and also harking back to a point that in terms of how the UK has gone, where they've got oversight boards and so forth, there's got to be a framework for those bodies, for courts and other systems to actually assess the tech solutions that are coming through. One of the trends that I've been starting to see is the development of impact assessment frameworks for pandemic tech solutions, sometimes called a pandemic impact assessment or review, or an ethical data impact review. I mean, we as lawyers, we're somewhat familiar with privacy impact assessment reviews. What would be the difference between, say, a straightforward privacy impact review and an ethical assessment, impact assessment, Mike?
Yes, well, the major difference is going to be, I think, on the breadth of what you're assessing or analyzing. For a privacy impact assessment, you're mainly thinking about, for this use of the data, what's going to be the impact overall on the key considerations for an individual's privacy, and how is that all going to play out? And it's really kind of tailored towards that. For an ethical impact assessment, it's much more broad. You're thinking about what are the unintended consequences of what it is that we're trying to do? What are the other lessons that we've seen from past similar actions that maybe we can think about in terms of what we're trying to do with this app that it will have down the line, such as, are we going to be teaching individuals to kind of conform to a certain type of behavior? Are we going to be, through this, using this app, kind of conditioning the population to expect the government to force certain types of tracking or contact notification applications to be used by handhelds? Those are the ethical implications. It kind of forces individuals to think about, what are we not thinking about? And of course, there's always going to be things that are missed. And that's the reason why there are hackers, right? Is that people that are creating source code want to think about how can someone hack in here, but they always miss something. And that's what hackers do, is think about other ways to approach problems. And that's what an ethical impact assessment would be, is thinking about what the application and its impact is going to have on society as a whole, not just from the frame of view of privacy, but in terms of what is this going to potentially do to society in the long run.
And Mohsen, in terms of the frameworks that I've seen for ethical impact assessment reviews, they typically have 3 prongs or 3 points to the triangle. An ethical assessment, a legal assessment, which would have a privacy aspect to it, but is not solely or exclusively about privacy. And there would also be a technology aspect to it. Could you speak a little bit about what would be involved in the technology component and analysis that would feed into these kinds of reviews and frameworks? Just to remind you, you're on mute there, Mohsen.
Yes, I should remember that. Sorry about it. Let me rephrase the question. I guess you're asking, how would I assess adherence to ethics and desired outcomes in technology-based solutions?
Yes.
I think to some extent, I kind of answered this question regarding general technology in the previous comments I made. So I like to focus on AI here, since that's an area that I've done quite a bit of work in. In my opinion, any AI-based solution should have huge overlaps between legal, ethical, and technological concerns. Additionally, even though this technology can currently make incredible discoveries that no human could, at present, AI lacks common sense and the ability to reason in a morally correct, human-like manner. So the responsibility falls on us model creators to ensure adherence to legal and ethical concerns you were talking about. But this is not always straightforward and requires some guidance by broader stakeholders, at least to my experience. And I can give you two examples. A bank notices that majority of home loan applications being rejected by their AI model assessing risks belong to African Americans, even though they had anonymized names and races in the data. After some investigation, they discover that the model was linking addresses of the applicants with level of risk and rejecting those in poorer neighborhoods. In another example, Google notices that searches for CEOs are returning very few women images. They look at the data and they see that currently only 5% of Fortune 500 CEOs are women. So the question is, should image search results for CEO reflect that number? Ultimately, a variety of stakeholders involved in both of these examples I just gave you evaluate the particular quote unquote harms and decided to alter the data to represent the future we would like to have rather than rely solely on past data. Now, for me, to get the desired outcomes and remain ethical in my industry, I would ensure all sources of bias are considered, including historical and representation biases during data generation and aggregation and evaluation biases during AI model generation.
Thank you, Mohsen. And maybe just to wrap us as we're drawing to a close, if I could close with these small observations. If you have listened over the last half hour, what you will have realized is how complex these issues are and how looking at any of the issues that we're facing in the technology that's coming through, if you look at them through too narrow a lens, you will miss the support that is needed for these solutions to be truly effective in their intended purpose. You can see the complex tapestry that's needed between things that happen between governments, above governments, at the governmental level, at the corporate level in terms of the development of these solutions, and at the individual level. And if you look at all corners and quarters of society, how they need to be heard, taken account of, and balanced. And that really is the challenge of the future in a post-pandemic world. And with that, I'd like to thank Mohsen, Kim, Mike, Agnieszka, and from me, Pádraig Walsh here. And I'd like to close on that and thank you for your attention, and thank you to Digital Week Online and Privacy Rules for